getting a chance to look in on a procedure in court that normally we don't pay a lot of close attention to here at the Law and Crime Network. This is the initial appearance where defendants go in front of a judge or a magistrate for the first time and basically answer for whatever they've been hauled into court for, whatever the arrest was. And sometimes these exchanges get a little bit testy. We're watching some of the back and forths today. But while we continue to march through the afternoon here on Law and Crime, we've got some other segments planned for you. One is a bit of an analysis of all the new state laws that are taking effect in 2018. Of course, with the new year comes new laws, and oftentimes many state legislatures allow laws to kick in with the start of an actual new year. Joining me to talk about some of these new laws is David Pietro. He's an attorney in Florida. David, good to see you again here on Law and Crime.
Thanks for having me. Happy New Year.
Happy New Year to you as well. And of course, I wrote on our website that with Father Time switching over to a new year comes Lady Justice with a series of new laws on the books. Some of them are a little bit more entertaining than others, and we didn't get into a full analysis of literally every single law taking effect in every single state, but we do have a lot of new laws hitting the books. One of them, which is an interesting one, I thought, is a Pennsylvania fireworks law. But the interesting part to me isn't so much the law, it's the details behind the law of what exactly they're doing. So just to jump into this one a little bit, you've got professional fireworks on the top of the regulatory chain. That's what professionals use to set off 4th of July shows and things like that. And then you've got novelty fireworks, which would be like caps for a cap gun or something, you know, like a sparkler. But then there's this middle ground firework that's different, sort of like a consumer prosumer mid-grade firework, and that's what Pennsylvania just ultimately legalized. So David, what can you tell us about this?
It probably sounds a little bit more like it's a tax revenue situation, and or they're recognizing what people are doing anyways, right? Fireworks are, the police could never regulate how fireworks are being set off and what's going on. They only fine or sanction people when there's a fire or some sort of accident. So it's just probably an effective way to bring practicality to what's already going on. At my state here in Florida, we do even something goofier. We give certain vendors special licenses to sell high-end fireworks. So if you go to the grocery store, you can only buy the sparklers and the ones that don't go bang in the air, or you can go down the street to the place with a license to sell the good ones, and it makes no difference who the consumer is. So fireworks is probably a weird area of law from state to state that's very state specific.
Yeah, exactly. Now, so Pennsylvania's basically legalizing these mid-grade fireworks, so they're more powerful than your everyday sparkler or firecracker or cap that would go in a toy gun, but they're nowhere near the professional grade. But still, they did put some specific no-nos in the law that people can't do with these things. Shockingly, they can't be used inside of a car. They can't be launched from a car. Okay, that seems to make sense, but hey, look, you've got to put it in the law if you don't want people setting off fireworks that do shoot up into the air from a car. They can't be used within a certain number of feet of an occupied structure, can't be used under the influence of alcohol or other drugs. But as you pointed out, David, I think the really interesting part here is they're going to sell them, they're legal, but they carry a 12% tax. That's pretty hefty as a sales tax goes.
Right, and this is partly a revenue generating, and it's probably revenue generating for firefighters with fire services. But you know, it's still hard to regulate how people discharge fireworks twice a year, mostly on July 4th. And you know, I used to have our bottle rocket and Roman candle fights. I guess that's still legal in Pennsylvania. So when I was a kid, so I guess we could still shoot them at each other. We just can't shoot them from cars or into cars.
Yeah, exactly. So you know, they're saying that of the sales tax that'll be generated from selling these things, up to $2 million worth of the sales tax revenue goes straight to emergency medical services and firefighter training. Now, that seems like a pretty interesting earmark for fireworks, for tax money from those devices going into EMS and firefighter training, when my understanding is that the firefighters and the emergency medical people opposed the bill. They didn't want this stuff out in the stream of commerce in Pennsylvania.
But you know what happens? A lot of these states, and I'm not sure about Pennsylvania, but Florida, we have a balanced budget amendment. So our budget every year in the state has to be balanced. We can't overspend. So a lot of times you'll see laws that are created to generate tax revenue for a specific service, and really it's a law that didn't need to be altered, but they just do an end around to create revenue for that particular service. So this might be something where they needed to create a line item for the fire services out of the state budget, and this was a practical way of doing it, even though the firefighters don't support it. I'm sure they're okay with the money coming in. They just don't support the actual practicality of how the law is working.
Yeah, exactly. So bottom line, in Pennsylvania now, you can set off fireworks, you can potentially, we hope of course this doesn't happen, but potentially cause injury and potentially set things on fire. But if that happens, just know that some of the sales tax revenue from your fireworks purchase in Pennsylvania is going to help train firefighters and EMS workers. Another thing I'll clarify about this one, it can't be used within 150 feet of an occupied structure. Apparently, David, you can set them off near a house as long as nobody's inside. I'm sure the home insurance industry loves that.
I'm sure their insurance lawyers will take out special exceptions in the homeowners policies and those documents that they mail to your house that you throw away as soon as you realize it's a policy change. So it's something for the lawyers to fight over if relevant one day. Yeah,
so that new law on the books in Pennsylvania, it took effect with the first of the year. Another one I wanted to talk about is got a funky name. It's an expungement law in Missouri. This is a law that basically says people with criminal histories can have some of those criminal histories wiped clean. And this happens in many states. What's interesting is that some parts of the criminal history is now easier to wipe clean. Other parts are a lot more difficult. David, how does the process work where you are?
So Florida, we have something similar to exactly how Missouri's doing it. There's certain offenses, if the offense is dropped by the prosecutors or there's a not guilty, we just change our state law. That not only is it automatically expunged, it's automatically taken off what we call an FDLE criminal history report, because it used to be the arrest would stay on there. It's been totally wiped out. Now, if you take a plea, we're a state, Florida still has what's called a withhold of adjudication, where you can actually be sentenced, but you're not adjudicated, convicted of the crime. And there's certain crimes that you can actually then seal, and the criminal history is actually sealed. I think in the long run, as a society, we've done this is probably a good thing. Seeing even from when I was a prosecutor, people do things maybe in the younger part of their life, and you don't want to carry a stigma for the rest of your life that you're a felon. I mean, basically, you make a bad decision at 22, your whole life is basically. It's destroyed. Now, this is not for sex offenders or murderers. This is for stupid stuff. I mean, even probably drug level stuff. It's probably a good policy in the long run that we're not taking citizens and giving them the F title, the felon title for the rest of their life, give them an opportunity to do a turnaround for nonviolent crime. So Missouri is similar to Florida, which is probably some states like North Carolina. When you're done serving your felony probation and your felony incarceration, when you're out of the system, so to speak, and you're back onto as a normal citizen, your voting rights are automatically restored. Now we don't have that in Florida. That's a much bigger fight for another day here. But there's certain states that even allow you just to go back through society, and other than carrying a firearm, you're back to where you started. And I think we'll see a push from a lot of states for nonviolent crimes. To stop labeling people for the rest of their lives.
Yeah, so the intent behind this Missouri law, David, is to basically allow people with certain felonies to wipe them off their records. The old law required a 20-year wait. The new law requires a 7-year wait. And as to misdemeanors, it used to be a 10-year wait, and they've knocked that all the way back to 3 years. But of course, look, as you mentioned, David, this doesn't cover the most serious crimes, probably never has. The new law actually expands the list of crimes that cannot be wiped off of a record. So this sounds like a compromise that probably went through the legislature to say, hey, look, less serious crimes will make it easier for people to wipe them off the record, but we're going to expand the list of crimes that cannot be wiped off the record at all.
Correct, yeah, and it's probably good public policy in the long run. Because I think what a lot of people don't realize is the criminal justice system isn't always just. A lot of times it's not. I mean, for example, you know, when we would try cases as prosecutors, if you pled, we would give you a lesser sentence. If you exercise your constitutional right to a trial, it's your right, and you lost, you would get a harsher sentence. So how many people actually plead to cases because they don't want to be the subject of a harsher sentence? So maybe they are innocent, maybe they're somewhere in between, or whatever it is. So we take a plea to move on with our lives, but then you carry that stigma forever of being a quote-unquote felon. So I think as long as the list doesn't include people that we never want to include, you know, sex offenders, murderers, I think even a lot of times kids that break into cars, I mean, we give them a big title like a burglary. And that's you know, for me as a lawyer, I know that you know, you broke into a warehouse or a car, you were being an idiot when you were 20. But to employers, Fortune 500 companies, they looked at you're a burglar, you'll never get a job there. So there needs to be some practical sense on how we apply the stigma of a criminal conviction. Now, if you continuously commit crimes, then that's to your own peril. But there is a large amount of people that actually fall within I made a mistake, I want to move on with my life exception a lot.
That's basically what the governor said. So when the governor who was in office in Missouri when this was signed in, Jay Nixon, he used to be the attorney general, so he used to be a prosecutor, basically said, hey, look, if people have paid their debt to society on certain charges, they ought to be able to rejoin society without letting that stigma, as you mentioned, David, mess up their chances at employment and other things. But again, the law does carve out a number of not only crimes that don't apply for this expungement process, this wiping clean of the record, but it also sets up a series of professions that can always look under the covers to see what's in somebody's criminal history as well. Certain licensed professions, even if somebody tries to expunge a record, it apparently would still be discoverable to those licensed professions. Now, that makes sense to me. I don't know about you.
It does. I mean, if I think the biggest exception in our society has to be for drugs, because there's so many people that become addicted to drugs. But you look at how opioids were sold in this country, and you have McKesson, the Fortune 5, the fifth largest company in the country, push more pills in West Virginia every day. But who gets arrested? Not the guy that got a $100 million bonus in San Francisco. The users get arrested, the doctors get arrested, but the big guys don't get arrested. And that's painting the obvious political picture that we just we go after the lower of the fruit, or the lower of the low-hanging fruit in the criminal justice system, and it's just not equitable in the long run. So hopefully the drugs and the crimes that are non-violent, that can move on. But if you're going to get a license and you want to be a nurse, a doctor, or a lawyer, I can understand special scrutiny, because now it's not about you, it's about protecting the public. So you know, obviously licensure issues and protecting the public, as you know, lawyers, you can get it sealed, expunged, do whatever you want. Every bar association wants to know everything about you, because obviously you're going to be encountering the public with a special license that holds you over and beyond just a normal citizen. So obviously that has a different weighing. You got to weigh the benefits. But bar associations, I've seen them with people turn their lives around, allow people to have a bar license. And so I think lawyers, we generally understand that life isn't always exact for everybody, and some people have a rougher road up to the top.
Yes, I would agree with that as well. Another interesting point about this Missouri law is it basically sets a limit on the number of times someone can get their record expunged or wiped clean in the first place. So you can't go into the system, then wait the shortened waiting period for expungement, and then get it expunged, and then get in trouble again and kind of rinse and reuse, repeat the cycle. There's a lifetime limit under this new law. So again, sounds like, at least at first blush, like a legislative compromise here again.
Yeah, it's a good balance. I mean, 10 years ago, when I was a prosecutor, we had, you know, when they were pushing opioids, if you had 50 pills, you were a drug. In Florida, you didn't have to prove the intent to traffic. If you had 50 opioid, certain levels of oxycodone, you were a trafficker. 25-year minimum mandatory. So you end up, you don't want the 25 mid-man, so you end up playing out 3, 4, 5 years in prison. But really, what were you? You were just a pill user. You're not a drug trafficker. And it's just really that this is where these titles and, you know, the laws paint, you get a title, you know, you were a drug trafficker, but really no one's ever going to read into it in detail and say, well, you a low-level user that got in a car accident, got addicted to this stuff for whatever reason, and then your doctors were giving it to you lawfully, and your whole life fell apart. But what people read is you're a drug trafficker. So this is where the laws, we need to be, as lawyers and policymakers and politicians. You got to be more practical on who you're trying to protect in society and for what reason.
And it sounds to me like the legislature in Missouri has spent a lot of time into figuring the parameters of that out. So that's one of the other new laws that hit the books here in 2018. If you're following along with us on lawandcrime.com, we've got a couple of days ago, the top state laws taking effect in 2018. There are probably hundreds, if not thousands of them. These are just a few that we selected for public debate, I guess, here. So another one here, David, California, a lot of new laws taking effect there this year, some of them controversial. A couple of them are supposed to be designed to help out people both applying for a job and once they have a job, being able to take care of their family. This is an interesting one. California has passed, and this has just taken effect, limits on what employers can discover when they are interviewing people for a job and then offering someone a job. One of those limits is on criminal history status. Okay, so this prevents the asking of information about criminal history status. Another limit that California has passed is basically shutting down discussions of salary history. They can't ask a candidate to say, what did you earn in previous jobs?
Yeah, this is where California kind of falls off the other side of the planet for the United States, right? They always go the extra mile. You know, it's interesting. I understand the debate on why you don't ask what your employee made from their previous employer. There's a similar law in Massachusetts that passed last year, and it was because of the disparity between females and males in actual income earning and generating. But as an employer, the only thing I would just ask is, what do you need to make? I mean, it's really you're beating around the bush to the obvious. The one with the criminal history to me is particularly idiotic, because as an employer, let's say I'm a lawyer and I run a law firm. Now, if I put somebody in my office who committed grand theft 4 times and I can't ask them that question, and they steal all the money on my trust account, do you think the Florida or the California Bar Association is going to say, well, you're okay because the law said you weren't allowed to ask if they were a thief? So I think that law is really dangerous in the long run. I think allowing people to expunge certain crimes and follow a system set up by the legislature is a great idea, but forcing private employers to not vet employees that might have access to money, might have access to the elderly, might have access to children, might have access to banking information, healthcare information, that's really bizarre and really over-the-top legislation, in my opinion, and not really practical. But that's California.
Well, there are some limits on it. Look, I mean, this basically says that it can't be asked up front as an automatic tool to disqualify. And we're talking about the criminal history provision here. Apparently, my understanding of this is that they can, in other words, they being an employer can ask about it once the initial thinning of the herd of applicants has occurred. So that's my read of this, that they can inject that conversation in there somewhere. And I think this applies only to public employers, not private. So you, running an independent law firm, a private law firm, you'd be able to ask the question. But if you were a government agency, you wouldn't be able to ask the question until determining that the candidate otherwise meets all of the other qualifications necessary for the job. And after that, then if you were running a government firm of some sort, prosecutor's office, presumably public defender, something like that, then the question could come in. So is this really just a game in semantics? I wonder if it is.
Somebody made a great bill, and they had a press conference after and said, we're so great, look at this great law. It makes totally no sense. So you're going to work for the Department of Children and Families, and what, you're going to have a prior criminal what if you had a prior criminal conviction for child abuse? It's really why even waste our time as employers, or even public employers, have to vet through applicants when you know that it's automatically disqualifiable? From a private employment, we would be held subject to liable if something bad would happen. What about the public? I mean, they should be held liable for for certain functions to make sure they're done, and it's a higher standard of public employment, not a lower standard. So to me, you're right. It's a matter of semantics. They're going to get around to it anyways. But I don't know what they're trying to prove, that the person's going to interview so great, and oh, by the way, I'm a 3-time convicted felon, and they're going to still get the job. It doesn't sound to me like this is really a law that has any value to anybody other than a politician that had a great press conference.
That could be, and I wasn't present for any of the legislative history of it. Maybe it's something that got watered down once it was run through the mill a few times. But look, I understand the points that you're making, and I agree with you, David. If we're going to, you know, what's the point in saying that a criminal conviction isn't an automatic disqualifier? In other words, you have to go through a couple of hoops and a couple of steps and a couple of jumps in the interview process before you then get a chance to ask the question. Well, in some professions, shouldn't it be the primary qualification? If you're handling money, you shouldn't have a conviction for embezzlement or something like that.
And I think the distinction is conviction versus arrest. If you're arrested and charges are never brought, or you're arrested and found not guilty, I don't think that there should be protections, because we believe in our Constitution, and anybody can be accused of scurrilous allegations that are not true, and that when you ultimately win, you shouldn't be then stigmatized for the rest of your life for an arrest. But convictions are different. I mean, you actually went through all the constitutional processes that we have in this country. So I think that's the very fine distinction. So policy-wise, I think arrest, not guilty, that should be taken off you're not guilty. These are the rules we agreed to play by. But conviction, I think it's different. I do.
I agree, and there are already protections on the law books in California for accusations without conviction. If it doesn't result in a conviction, my understanding, based on my research into this new law, is that if it didn't result in a conviction, then it's off the table. That can't be discussed. So that protection already exists. This new one is a little bit different. Another interesting California law, of course, recreational marijuana use has been legalized in California starting with 2018. A lot of interesting stuff wrapped around that. Okay, so recreational use is legal, but you can't drive a car while you're high or ride in a car while you're high in California. They legalized it, but then they passed a protection. I don't have an issue with this, David. I don't know about you. It's just like a drinking and driving statute. Same thing. Public protection.
Can you shoot fireworks, though, and smoke marijuana?
Well, you know, now we're plugging Pennsylvania law together with California law, and I haven't gone there yet. I don't know. But well, to answer the question, no, because you can't ride or drive while high in California. You can smoke it, but you can't drive under the influence.
Well, you know this. DUI laws in this country only get more stringent, not easier. Mothers Against Drunk Driving have taken a stance for the last 40 years, really making the consumption of anything that will affect your normal faculties and driving a very serious offense. So I'm not surprised whatsoever. The insurance companies were going to push this kind of legislation and make sure that their drivers, it's a crime for them to be intoxicated or their faculties to be impaired while they're driving. And again, goes to that law. Is if you want to smoke, you know, the government's, there's two theories, right? If you want to protect me from me, that's an issue if I just want to smoke marijuana. But if I smoke marijuana and drive, you're not, as a societal issue, you're protecting other people who choose not to live that way. So it's that old saying, your rights in where my rights in where or my rights in where my nose begins. So it makes sense that you would have these kind of laws, because you know you could actually hurt somebody else. But you know, I think in our lifetime, probably in the next 10 years, marijuana will be either decriminalized or regulated nationwide. You can see it already coming.
It seems that that's the direction that things are heading, but if it is, look, we'll be here to cover that story as well. And just remember, you can't drive with it assuming that they're going to pass that law as well. An interesting thing that's also been plugged into this, David, and I didn't put this in the original piece that I wrote for the website, but there was a bust, and we were talking about this a little bit before we jumped on the air here, where a marijuana dispensary that was getting ready for this first of the year recreational marijuana law was transporting a bunch of this stuff, and they got busted. and they turned around and handed the California Highway Patrol their county level license, but the state license doesn't go into effect until the first of the year. So this bust happened a week or two ago. They, in theory, could be found guilty under the old law because they jumped the gun.
Right, and I guess the question is whether the prosecutor is going to actually file a case like that and go in front of a jury with a straight face and say 6 days later it would have been legal. I guess the only thing that could really happen is it's still illegal under federal law, and the question is could they be prosecuted federally? But it seems that the Department of Justice has somewhat given up on marijuana in a lot of respects, but it seems like a play on technicalities. It would be sort of embarrassing to be filed by a prosecutor and actually prosecuted, and wouldn't really be appropriate given the I understand it meets the letters of the law, but it really, this is where the practical part of law and not the black letter of the law come into play. It really it sounds like these troopers overstepped.
Well, look, I mean, as you pointed out, David, in theory they're correct, but I can't for the life of me picture a prosecutor actually going forward with the case. Unless the snarky side of my brain takes over and we say, you know, look, people can rack up court fees just getting a case dismissed. We can shake them down for a couple of bucks. I don't know if that's exactly what's happening, but the nefarious side of my brain certainly is curious.
It makes me think that, remember, troopers are different than sheriffs and municipal police officers. They're always very highway. I mean, they're in most states, like in Florida Highway Patrol, the 90% of their function is the highways. This might have been them telling the legislature and the governor and all the lawmakers that they're not happy about because of the impact on the highways and roads that this may cause. So this might have been more of a message to the lawmakers than it was to the individuals transporting the marijuana.
It may be, and we could continue to read between the lines, try to figure out what's going on, but my next piece of research on that little part of the puzzle is to try to figure out whether the prosecutor is going to move forward with the case. So, moving on in our analysis of new laws that are taking effect, or that I should say have taken effect, with the stroke of midnight yesterday, right with the first of the year, we have family leave acts taking effect in New York and California. These are being billed as family-friendly measures, making it easier for mothers and fathers to basically take time off from work with the birth of a new child. In New York, private employees can now take time off from work without losing their jobs or their entire paychecks or their insurance, their work insurance, to, quote, bond with a newly born, adopted, or fostered child, to care for a close relative with a serious health condition, or to assist loved ones when a family member is deployed abroad on active military service. When the leave period ends, New Yorkers are allowed to jump right back into the job that they took leave from. In other words, the job still has to be there. The catch is that the paycheck guaranteed during the leave period is half of what the employee would normally earn. There is a very complex formula, but that boils it down to the simplest version of it. So bottom line, David, what do you think? Do you think this is going to help people who need to take time off from work if a workplace doesn't have a generous leave policy? Is this going to help fill a gap?
Well, it depends on whose rights you're protecting, the employer or the employee. This is going to raise the cost for an employer to employ somebody because they're going to know. And honestly, what could happen is employers might not verbally say it, but they might try to avoid hiring women in childbearing years and a roundabout way because they know that they could be subject to this type of responsibility for the employee. Just like there's some employers that will hire somebody at 66 but won't hire them at 64 because they don't want to pay for the health care, and at 65 they're on Medicare. So there's sometimes we try to equalize things that are hard to equalize, and they have they're well-intended laws with adverse effects. It's hard to say whether this could actually be a great law that helps employees, or it could be one of those ones that sounded great and then it just had this adverse effect. And the only ones who's going to make money on it are the lawyers that file lawsuits over it. So it's hard. It's like it's what I call the puppy dog laws. We all want to pass laws to help puppies, but do you actually hurt the puppies not get food because you pass the law that way? So It's hard to say. It could be great, or it could be technical and not so great and have adverse outcome.
I suppose it's yet to be seen exactly how this could become litigious, but of course it could. And what I was picturing, David, was actually the number of lawsuits that are going to claim that there's some pretext. You know, somebody took leave and then they came back and they worked for 6 or so months and then they were fired for some sloppy error that maybe everybody else makes, and then they say, well, that's just pretext, you're really mad because I took leave. I was envisioning the possibility for those kind of suits.
Right, I could definitely see that, and the problem is too is if you have no children and you decide to have a child, you don't realize what obligations or how that's going to change your life. So that might actually affect your work life, where you would need to go to your employer and say, listen, I know I work 55 hours a week as your associate in your law firm. I can't do that anymore because I have a child. So I need to be fair to you. You need to be fair to me. I want to stay part of this team. But now an employer might be in a catch-22 in that scenario, because if there's a change, there should be. I agree that employees should not be terminated, fired for having children, things like that, or having sick relatives. But the question is you got to make it fair to both sides. Otherwise, it's not going to work. It's going to have unintended consequences in the long run. But I definitely think you're right. You're going to see more lawsuits. People are going to come back to work. It's not going to be the way that it used to be, because it's not the same on both sides. You have employee has new obligations, an employer needs to work around that, and it can become a change. It doesn't mean it's bad. It just needs to be open and honest with and transparent. But I don't know if this law is going to fix that down the road.
Yeah, I mean, I hear you, David. And I suppose it's possible that could happen. But, you know, another thing I'm looking at here is that the paycheck during the leave period, which, as the law starts, is up to 8 weeks for full-time employees. The paycheck gets cut in half. So there's some income coming in, but it's half of what it usually is. Part of me wonders if it's going to create a market for people who kind of run around within professions, especially highly skilled professions, where they're jumping around filling the gaps where someone is out on one of these leave windows.
Yeah, it could be. It could be. It's hard to say. You know, if you look at the Family Medical Leave Act, which we've had since the early '90s, it's had some good things that protect employees, and some of it hasn't been so great. It's always that struggle between employee and employer, and sometimes when the pendulum moves too far one way or the other, you have inequities. So there's a happy balance. I don't know if this law swings it on an unhappy balance. It's hard to say, because you have to see, is there a prevailing party attorney's fees provision in this law? If there is, lawyers are going to be looking at finding these cases to file suits, which is just going to aggravate employers more. And it's just what are the, it's like the Americans with Disability Act, one of the most well-intended laws, but the adverse effect of it is we have these down in Florida, these career plaintiffs that they take satellite pictures of areas where they know that the disabled folks can't get in and out of, and they go do staged lawsuits. Well, that wasn't the intent of the law, but they can do it. So it's one of those things. Where's the balance between making sure people are treated fairly and not adversely affecting it for everybody? Exactly.
Well, we've been talking about some of the new laws that took effect with 2018 coming in, the new year, new laws. David Pietro, attorney in Florida, appreciate you joining us for some perspective on these.
Thank you. I appreciate it. Happy New Year, guys.
Thank you. So we're going to continue